Hello, welcome to the Owatonna Today Show. We have a special treat today. We are going on location, or have gone on location, with Judge Karen Duncan at the Steele County Courthouse. And you know, if you have suggestions for future shows or topics, please feel free to contact us and let us know. You can contact us on Facebook, or you can give us a call or email us. We really would like to hear from you. In the meantime, please stick around for our interview with Judge Karen Duncan after these messages.
Company, certified public accountants, we support the Owatonna Today Show.
Owatonna Public Utilities, real people, real reliable, real progress. Making life a little easier day after day, taking pride in our community, listening to what you say, a voice you can talk to. We're growing with you in mind in everything we do. Owatonna Public Utilities.
Greetings from the Steele County Historical Society. We invite you to visit us and enjoy your county's history at the History Center and Village of Yesteryear. For current exhibits and events, check our website, www.steelehistorymuseum.org.
Welcome back to the Owatonna Today Show. We are here in chambers with Judge Karen Duncan. Thanks so much for inviting us in. And
oh, my pleasure.
It's good to see you.
Well, it's nice to see you as well, Francie.
Yeah. So this is your second year on the job.
I've just completed my second year, actually.
Yes.
Time flies.
Oh, my goodness. And so you are the first female judge in Steele County.
Yes.
Okay. And so tell us a little bit about yourself and the process of becoming a judge and the experience that you've had before becoming a judge that has brought you here to this place.
All right. Well, my family and I moved here in March of 2000. Basically, I was looking for a way to get back to Minnesota because I'm from Minnesota originally. I grew up on a farm in southern Minnesota. Mm-hmm. And I had lived in Faribault before and practiced law there as an assistant county attorney. And I had also been an assistant county attorney in Olmsted County, where Rochester's the county seat, and really enjoyed this part of Minnesota. So when we had the opportunity to move back, we considered a number of factors. We chose Owatonna, and we have been so happy to be a part of this community.
It is a great community.
It's been a wonderful place. My road to getting to law school was a little unusual, perhaps. One thing I knew growing up was that I didn't want to be a farmer because it is way too hard and unpredictable.
Being a judge isn't hard, folks, right?
My kids like to tease me because they say that they've never met anyone who's done more different jobs than I have.
Oh my goodness.
Which I think has been a great way to prepare for my current position. Because as a judge in a general jurisdiction court, we have 2 judges here in Steele County, we hear everything from the small claims court, which we actually call conciliation court, but that's where people with low dollar amount cases can come to court in a pretty quick fashion to get their matter heard by the judge and get it resolved in that fashion. And we do marriage dissolutions, we do criminal cases, all the way through homicides, which hopefully we don't have any for a good many years to come, but you know, from time to time everybody does experience that kind of tragic crime. So when you preside in a general jurisdiction court, you have to know so much about so many different things. And I knew that taking the bench, it's one of the things that I really enjoy about the job, is that every day is something new. It's an opportunity to go into the computer and do some research and learn about something that I didn't know before, and to see how that fits into the larger picture of the law. So that's an encapsulated version of your questions, and I'm not sure, Francie, that I hit everything.
I love what you just said, though, about, you get to learn more, and you get to, you don't know everything, and it's the people who think they know everything that we got to worry about. But,
True.
That's really good to know. You've had a broad array of jobs that led up to this, and you said that you were an assistant county attorney, and is that in prosecution?
Right. And so I did about half of my career in prosecution.
Okay.
I took a step away from that, and I was in a 5-lawyer law firm when I was still living in Iowa with my husband.
It's a private firm?
Right, and so I did some court work there as a guardian ad litem, which is an attorney in the Iowa system who represents the interests of children in child protection and juvenile cases. And I also did family law work in that law firm, and then a little bit of this and a little bit of that, as small firm practices generally do.
Sure.
And then when the opportunity came up, I did a small contract as a public defender in the Iowa system. And when I moved back to Minnesota, I had my own practice here on North Central Avenue. I had some really wonderful clients that I worked with, and I got a contract with the public defender's office because they had too much work and not enough people. And then within a year, that became a full-time position, and I worked my way up through the public defender system. So that's what I was doing most recently before I came on the bench.
Right, okay. That's a broad background. Prosecution, defense, civil, personal, all that stuff.
Right.
That is great. So, you know, you've been in it for 2 years, and I'm kind of curious if there's anything that surprised you about the job of being a judge.
There's been a couple of things. One of the things I did know coming in was that there was going to be a lot of learning, but the state court system invests so much in training new judges. It's a very rigorous program, and so I was very grateful to have all of that hard training because I think it better prepared me. And then in the job itself, one of the things that's difficult is because we have more judge need here than we have actual judges, is trying to figure out how to best use the unexpected gaps in time. So we have our schedule, of course, planned out months in advance, and life happens and schedules get upended. And so I don't know, stepping off the bench this morning, am I going to have a 5-minute break or is it going to be a 35-minute break? What can I do in the space of time that I have?
Well, you're not actually in the courtroom hearing cases.
To effectively take care of things, because what people see is we're in court most hours of the day, but we also take cases under advisement, which means we want to think about them, do some research, reread the pleadings, and so that all happens when we're not in court.
So there's work outside of the courtroom. You come back here and you've just heard all of this,
Yes.
and at some point in the near future you're digesting it and trying to think of it in new ways and do research about it in order to what? Come up with your decision?
With
In the
the
case?
fairest decision, applying the law to the facts. Using my common sense and experience too.
And all the training they gave you.
Right.
And all the many, many years of different kinds of things that you've done, which is really great. So you were surprised by
Well, I was surprised by how difficult it was to try to make that transition and use every minute well. So that was a surprise.
When you're understaffed and kind of there's way more cases than 2 judges in this courtroom can hear.
Right.
Okay.
And the other thing that surprised me was when people come into the court system, they don't necessarily understand they should begin with the end in mind. So you should know when you come into the courtroom what it is you need to prove and what the legal standard is. And when people choose to represent themselves, that's particularly important. And we've got a lot of wonderful self-help tools for people who choose to represent themselves, but it's still a very scary and anxiety-producing process for people. So if they know coming in what it is the legal standard is and what it is they have to prove, they'll come out feeling much better about the process.
That is tough. When you're so individuals can represent themselves, and that's called what, pro se?
We now say self-represented litigants because pro se refers to Latin, and people generally don't speak Latin.
Okay. Somebody's phone is going off in the background.
If that happened in the courtroom, that would be a problem, but we're back in chambers and that's my phone, so
Okay,
I'm not going to sanction myself.
If you were in the courtroom, you would say, turn that off.
Yes. Well, the judge has a lot of roles in the courtroom, so I have to be able to listen to and understand the cases. I also have to pay attention to the overall control of the courtroom. And so there are oftentimes people who are waiting for their chance at the attorney table to tell me what's going on. And so they can't be doing something that's going to be distracting or disruptive to the proceedings. It's not fair to the other litigants, and it makes it harder for me to do my job. So the most common disruption we have is cell phones going off. It doesn't happen very often. People are very cautious about that, but it does happen.
Right, you can't be distracted when you've got very little time and a lot to get through, and also the people who are up in front of you may be nervous, and we don't
want them to be distracted.
Exactly. Too, lose their train of thought.
Exactly,
Okay.
and we don't want to have someone who's sitting in the gallery making faces at or trying to influence somebody who's in the litigation. There's so much more going on in the courtroom than the people presenting their cases.
Right.
That was another thing, I guess, that surprised me a little bit. They told us in the training there are no less than 5 things the judge is doing at any given moment in the courtroom in order to be a good and effective judge.
Sure, you're listening to things, you're directing what's happening and when, you're keeping an eye on
Right.
the whole proceeding and what's going on in the background so that everybody is being heard and not distracted, and that there's also no dangers, I presume, too. I mean, I'm assuming
Security is an
security
issue.
Staff. Do you have security staff in the courtroom?
We have one security officer for the whole building, and you probably saw when you walked in this morning that there's a metal detector at the
Yes.
door. The sheriff is working to get the metal detector staffed. As I recall, the metal detector came to this building through some grant process, but the grant didn't have funds attached to it for personnel to man the metal detector.
Okay.
So it's not in operation every day that we're open.
Okay. Well, we've got a lot more to talk about with Judge Duncan, so we're going to come right back after these messages. Stick with us.
Hi, I'm Christine Johnson, and I play Annie Bonnie.
And I'm Ron Hager, and I play Long John Silver in LTO's current production of Treasure Island, directed by John Terrell and sponsored by Federated Insurance.
Performances of Treasure Island will be held Friday and Saturday, April 17th and 18th at 7:30, with a matinee on Sunday, April 19th at 2 p.m.
And again the following Thursday through Saturday, April 25th, 26th, and 27th.
Tickets are available at the LTO box office by calling 451-0764 or online at littletheaterofowatonna.org.
Don't miss LTO's production of Treasure Island. And if you miss it, I'll make you walk the plank.
You better get there, matey!
Recreational fires are allowed within the Owatonna city limits. They must be contained within a fire pit or a device designed for such use, and can be 3 feet in diameter and no more than 3 feet high. They must be 25 feet from a building or combustibles. Only untreated or unpainted woods must be used. Fires must be attended by a person at all times that are capable of extinguishing the fire. This has been a safety tip from the Owatonna Fire Department.
Hi, I'm Glenn Mager.
And I'm Tim Thomas of the Brick Mager Funeral Home, and we're proud to serve the Medford and Owatonna areas with cremation and traditional funeral services.
And we're proud to be a part of the Owatonna Today Show.
Hi, this is Barry Gillespie, president of ERA Gillespie Real Estate, where our pledge is to save you money, save you time, and simplify your life. And we're proud supporters of the Owatonna Today Show.
Hello, I'm David Einhaus with the Owatonna Foundation. Thank you to all of our donors who have helped make Owatonna a better place to live. Will you join us today with a financial gift? Owatonna Foundation is a proud sponsor of the Owatonna Today Show.
Welcome back. We are back with Judge Karen Duncan in her chambers. We're in the inner sanctum, and we're going to learn a little bit more from her, specifically about a couple of things, which we'll let her touch on. One is drug court, and the other is a new system. It's the
E-court.
E-court system. But also, we just want to get down to basics with, how is it that a criminal case or a civil case gets to the point where they are being heard in front of Judge Duncan?
Well, let's start there, Francie. So there are basically two general categories of cases that come through the court system. There's criminal, and that's what people are probably most familiar with because you see it on TV, you see it in the movies, and it's covered often in local media as well. So in a criminal case, there's a prosecuting authority. Generally, it's the county attorney, but also the attorney general can initiate criminal cases. And there's a complaint that's filed. So that's a document that sets out what the specific criminal charges are. And then there's a short story, if you will, that's called the probable cause statement. And that has to contain enough facts to support the crimes that are alleged. So when the county attorney prepares that document, an officer who was involved in the case or whose agency was involved in the case reviews the document for accuracy, signs it under penalty of perjury. The prosecuting authority signs it under penalty of perjury.
So they can't be lying because
So
they'd be liable for a criminal offense themselves.
Absolutely. They take it very seriously. And then they actually file it electronically. So Judge Butel or I get an email message that says we have a new complaint to take a look at. And then we go into the secured system. We're able to pull up and review that document. And then we've got options. So if, for instance, probable cause might be lacking on one of 3 charges, we can note that. We decline to sign the charging document, and then the prosecuting authority has a chance to fix it if they can, or delete that charge if there aren't facts for that charge. So we review it. If we're satisfied that there's enough information alleged in that probable cause statement, we'll sign it, and we can either order someone to appear on a given date and time, we can order that they be picked up on a warrant, and we can either order that they be held until they're seen in court, or that if they're picked up on the warrant, they can be released by posting a certain amount of bail and following certain conditions. So there are different options there. Once a person gets that charging document, they come into court, they're advised of their rights, which include the right to be represented by an attorney. And a number of people who find themselves on the receiving end of that charging document find that they can't afford to hire an attorney. Some people can, and that's great. We've got a number of terrific lawyers who can represent people in this community. But if people can't afford an attorney, the court system is set up so that they still have their rights protected. They can apply for the services of the public defender, and if they earn less than 125% of the federal poverty guidelines, they then would be appointed an attorney to represent them. Some people have the ability to pay a little bit toward their attorney, some people can't pay at all, and as the presiding judge, we have the opportunity to watch how that person's financial circumstances are going throughout the process, and we can have them make reimbursement at the end.
I see.
If their circumstances improve
So they
financially.
may be using a public defender, but their circumstances may enable them to pay some money or all of the money for that public defender. Okay.
Some people come in and they've been arrested and they've lost their job because they couldn't go to work when they were arrested. But they can get a job after they get released if they're released on conditions. And so that's a circumstance where somebody initially qualifies but then later might have to make some reimbursement. So then the criminal process is set up to make sure that both sides are exchanging information, because we don't want to go into a trial with one side or the other blindsided. That's just fundamental fairness there.
So they have to, the prosecution has to disclose all of their stuff to the defense, and the defense needs to disclose theirs to the prosecution so that everybody knows what the facts are and what they're dealing with and who's alleging what.
Right.
Is that it?
Right. It's not exactly equal, though, and I should make that clear. From the defense perspective, if they do investigation, they only need to turn over the information they have that relates to witnesses that they intend to call at trial. So there may be leads that they follow up on that don't go anywhere. They don't have to report that kind of information. But it's anybody who's going to come and testify at trial, the other side should be well aware
If
what
they're bringing
that person...
something or someone into court, an argument or a person, that needs to be disclosed to the other side. Is that right?
Well said.
Okay.
Well said. And so then, through the process, the person accused has the opportunity to challenge whether evidence was obtained in an illegal fashion, and if the court determines that that's what happened, then that particular piece of evidence wouldn't be used at the trial. Sometimes that means that the case falls altogether and is dismissed at that point. That doesn't happen very often. The case can move forward either through a negotiated settlement, and that's what happens in probably 95% of the cases.
Is it they settle through some process of negotiating?
Right, through some back and forth, yes, I did something wrong, but it wasn't as much as you think I did, or it wasn't as bad as you think it was, or, something of that nature. Or, yes, I did it wrong, but I'm just concerned about what's going to happen in the punishment phase, and I want to make sure that I can continue my job and those types of things. So they can negotiate those.
There's agreements made between the parties that you don't want to approve. You say, this is a deal that I'm just not going to approve.
Yes. Again, that doesn't happen very often, but occasionally we have circumstances where the negotiation is the person says, I'm going to plead guilty to a specific charge, however, I am not guilty. And that doesn't sit well with me. That's not what the criminal process is about. Mm-hmm. And so if they're not guilty, they should move forward and have their trial and have their day in court. Jurors in this community take the process very seriously. And, they come, they listen carefully to the evidence. The cases weigh heavily on them. They want to make the right decision, and they're concerned about making the right decision. So I would hope that people don't give up their right to a jury trial because they think somehow people won't be fair in that process. That's really not been my experience either as an attorney or as a judge.
That's very good to know. Don't plead guilty if you're not, and leave it in the hands of people who are going to hopefully have your best interest at heart, which is what you're saying that you've seen. This brings us to, though, another thing, which is drugs are involved in so many crimes.
Right.
And so you were talking about earlier to me about the drug courts, which you call something else. But so tell us about the drug courts.
I think it's important, Francie, that people understand that a person might be charged with a burglary, and that might be their crime, but it may be motivated because of a drug addiction. And so it's not just when you read in the newspaper that someone's been charged with this drug crime or that drug crime. It's so many more crimes. And what the research has shown over the last 25 years nationally is that this process that's commonly referred to as drug court, which is really an intensive supervision, an incentive and sanction program, is very effective in helping people climb out of that hole of addiction.
Okay, and you said, so climbing out of that hole of addiction through sanctions and incentives. And what are those? So if I'm a drug user and I've committed a crime, I'm gonna have some sanctions against me, meaning some kind of a punishment or something.
Right.
And I'm also gonna have some incentive to get better. What are those?
Okay, well,
examples. I mean, you can't give all of them, but
in the normal criminal process, you would likely be put on probation. You might have some jail time. You might have prison time hanging over your head. There are standard conditions of probation. Be law-abiding, get a job, pay your fines. If you need treatment, go to treatment and do treatment. And then your level of supervision through probation depends on how they assess your risk. Drug court, which I prefer to call recovery court because that's really what it's about.
Recovering addicts, recovering communities,
Yes, recovering at all levels. Mm-hmm. We all succeed when we all succeed.
Isn't that funny how that works?
Yes. So the drug court is specifically tailored for people who are high need, high risk. So it's not just their drug addiction, although that's one of the factors for eligibility, but they have a whole constellation of interrelated problems. And in order to be successful, we can't just say, well, go to treatment, and once you've done treatment, you'll be fine, because they likely won't be.
It's just one piece of that puzzle,
and
the rest of it's falling apart over here.
It's one piece.
And I think we're getting close to our end, so,
okay.
So what's the most important thing you want to convey about this rehabilitation court?
People come in to recovery court. They see the judge every week when they're in phase 1 of the program to report on their progress. If they're doing well, they get kudos from everybody. They might get a little gift card, a $5 gift card here or there or something. That's an incentive.
So there's an incentive.
Just to reinforce the good behavior. If they've had problems, then the disincentives are, if it's a really serious situation, you might end up back in jail. But otherwise, there might be other ways of dealing with that to help the person get back on track. So the drug court is meeting with the drug court staff on a regular basis, being tested no less than 3 times a week. weekly home visits.
So it's more intensive.
It's very intensive.
And there's a lot of FaceTime with the judge.
Yes.
Okay.
And
the
Judge
judge
Butel is the presiding judge for that.
Okay.
I back him up when he's unavailable, but
Thank you,
that's
Judge Joe Butel, for that.
absolutely.
Okay. I think we're going to wrap it up here. So we didn't get to talk about eCourt, which is just
Well,
really
next
the
time.
paperless thing, but we will talk about it next time. Thank you so much for joining us.
Thank you,
I
Francie.
really appreciate it. And thank you for joining us, too. Come right back, and we'll see you soon. That was a really stupid ending.
Amy Swain Hearing Centers is a proud sponsor of the Owatonna Today Show. I'm Dr. Amy Swain, and I want everyone to hear better.
Hello, I'm Sean McNulty.
And I'm Deb Gillard with Brookdale Senior Living, Sterling House, and Clarebridge of Owatonna.
And we are a proud sponsor of the Owatonna Today Show.
Okay. Hi, welcome back. It is time for your community connection. So let's get into what's happening in Owatonna. Again, we've got the complimentary screening with the Shriners Hospital. That's coming up Saturday, April 25th, 9 a.m. to noon at the Owatonna Public Library, the Gainey Room. And that is available to any children and families that have bone, muscle, or joint conditions to screen and see if they can get some help from the Shriners Hospital. In Faribault on April 26th, there's the Riverbend Nature Center celebrating its 10th annual Maple Syrup Fun Run, and that includes a 10K trail run, a 5K trail run, and a 1-mile walk, and also the pancake breakfast that is at the Interpretive Center. We have Bark and Rec coming up on April 25th. Bark and Rec is back. The event will be held Saturday, April 25th from 9 to 1 at the Four Seasons. It's free to the public and to their furry friends. Treats, groomers, vets, demonstrations, and other doggy stuff, all under one roof, including dogs available for adoption from Steele County Humane Society. Also on April 25th, actually, at the Four Seasons from 1 to 4 is the Munchkin Market. So stick around after Bark and Rec for the Munchkin Market. We've got youth ages 6 to 15 that can sell their old toys, their games, their books, sporting goods, and more. And then we've got on May 2nd, we've got Spay and Neuter Clinic. The Steele County Humane Society is offering low-income spay and neuter services. Please contact MN SNAP at 612-720-8236 for an appointment. Celebrate May Day Tea at the Owatonna Arts Center May 1st, Friday, 4 p.m. at the Arts Center. Tickets in advance. You can get those from the Arts Center. They are $8, and they must be purchased by April 28th. We're so glad that you tuned in today, and if you have suggestions for future guests and topics, we invite you to share them on our Facebook page or call or email us with those. Meantime, please join us on Friday for an update with Chris Boosie and new employee GIS Director Ruben Seifert, and then later Brad Duchat with Senior Place.